Mr. Giuliano, are you going to offer this document evidence? Well, yeah, I was planning on doing it, but first I wanted to get the witness to authenticate the document, that it is what it purports to be, and then I'm going to try to move it to evidence. Well, Mr. Giuliano, you need to tell us what documents you move into evidence before you even show it to the witness. We don't even want you to show it to the witness until you say it's going to be an exhibit. We've had that sort of thing happen. This was someone who's a trained lawyer. The bottom line is that you look at people on paper, and what they look like on paper sometimes need to be a lot different than what they are in real life.
How about word of mouth? How about talking to
well, we do that.
Find out if people really are.
We call other practitioners. We see someone else we know that is listed as a former arbitrator in one of these cases. You call the opposing counsel, or you call somebody you know and say, hey, you had Mr. Smith on your panel. Looks like you won your case or you lost your case. What can you tell us about Mr. Smith? And they say, well, he's a nice person, or she's a nice person. We thought that they were fair. Even though we lost the case, we thought that they had good control of the proceedings. They made sound evidentiary rulings. They responded to objections. They were diligent. They read the materials. They showed up prepared. They weren't looking at the clock all day. They weren't falling asleep, which has been known to happen. And, you put them to sleep, you wake them up. But you ask fellow practitioners about what they think of those particular arbitrators. But still, I mean, what's going on with the industry arbitrator is that you might have someone who worked for 10 years at Merrill Lynch and for 10 years was a branch manager, but unfortunately it was 10 years ago. And for the last 9 years, the person has been a missionary in South Africa. Okay? Well, that person is going to be classified as a public arbitrator, even though their background is essentially from the industry. New York Stock Exchange doesn't have that. New York Stock Exchange, if you've devoted a substantial portion of your professional career to the industry, if you work in the industry, you're an industry arbitrator. And the reason why is because, again, it goes back to the folklore arbitrations. The industry representative is the person who gets to decide whether or not the conduct at issue is consistent with the customs, practices, and habits of the industry. So that's the industry person. And the industry person is probably more important than other public people, because when they have their deliberations, it's the industry person that says, well, what this person did really wasn't all that bad, or what this person did. Now, sometimes the industry person can be your best friend, because when there's really outrageous conduct, the industry person says, I can't believe this happened. I can't believe this person got arrested for buying drugs twice and it was not reported. The industry person is going to be outraged sometimes by the facts, but sometimes the industry person is not going to be at all sympathetic, because the industry person, particularly if there's a compliance person or a branch manager, when we see branch managers and arbitrator selection forms, we just cross their names off. Why? Because there's two missions for a branch manager: rallying the troops for sales purposes and denying customer complaints. So an industry person who's a branch manager is going to be, unless you have an outrageous set of facts and you want that person to be on your side because the facts are so outrageous. In a suitability case, the industry person is never going to have a problem in a suitability case. A branch manager is not. So who do we look for? We look for analysts. We look for, even though we don't like it, accountants. People who are not financial planners. People who have more of a are less sales oriented, that are less compliance oriented. The last person you want on your panel is the general counsel, the in-house counselor, some brokerage firm who's in the compliance business. Because again, they didn't get that job because they believe in claimants' rights. They got that job, and their whole mindset, their reason for existence, is to defend the firm when they have regulatory problems, and to defend against customer complaints. Because after all, everyone knows the stock market goes up and down. If your broker tells you to buy securities and you're 85 years old and have an 8th grade education, you should know better, because after all, you grew up during the Depression, all heard about the crash of 29, so you should all know better. That's what you'll get from the industry person. Well, recently the NASD has tried to reclassify some of those folks to say that if you have any background in the financial industry, that in fact you should be reclassified as an industry arbitrator. But invariably we'll see people who worked at brokerage firms more than 5 or 10 years ago, who have a background in the business, who are defense-oriented, who are classified as public arbitrators, even though they're really not public arbitrators. So you look at those people, and what kind of people want to sit on arbitration panels? Well, you're going to get basically, two types of people. You're going to get the people who have a legitimate interest, and it's pro bono. I mean, they get $1,200 a day for a hearing. Excuse me, $400 a day, $1,200 for 3 days. They're not doing it for the money. You have a lot of very fine arbitrators. Our